recorded, and the link and instructions for playback will be posted out to the website in a couple days. The format of the meeting is going to be question and answers. First, we have some common questions queued up, and at the same time, we will be actively monitoring the group chat for questions for later on. So with that said, let's get started. We have three panelists this evening to answer questions. Attorneys David Anderson and Matt Davis, along with fellow plaintiff Tom Stair. Okay, the first question, what is the lawsuit objective? Homestead parcel owners want control over how their restrictive covenants are enforced and how their fees are spent. How many individual class members support the class action lawsuit? As you can see by this graph, over 800 class members are in the class action and 64 have opted out. Okay, starting our common questions. The first question, I just received a letter from Homestead threatening me with further action if I don't become current on my maintenance fees. What should I do? Matt, do you want to go ahead and answer this question?
Sure. Hi, my name is Matthew Davis. I'm one of the attorneys for the class and have become so enamored with the area. By the way, I moved here from Seattle. But in response to this question, the April 30 letter that threatens further action is rather ambiguous about what that's going to be, probably because there isn't that much they can really do. So because this is an assessment of sorts under a restrictive covenant, in theory, they could file a lien against a property for failing to pay. The other further actions they could do would be to send it to collections or to file a lawsuit on it. And I know the word lien scares everyone a lot, but it shouldn't really, because a lien is just a claim. So the biggest thing they could do would be file a lien against your house. If they did, the sheriff's not going to come kick you out. They would have to file a lawsuit on their lien. And in that lawsuit, they would have to prove the amount that you owed and you hadn't paid it. And if they proved all those things in the final trial or whatever, then the court would give them a judgment on their lien and set a sale date, a sheriff's sale, which is an auction, at least 30 days out. And at any time in the process, you could simply pay it. By pay it, I mean pay the amount with 12% interest. So they're threatening further action because they don't want to say what they might do because there's not much they can do. And so all I can say is that, what I would say is this: in the history of Homestead, not a single lien has been filed for maintenance fees. Not a single lawsuit has been filed for maintenance fees. It seems highly unlikely that Mick and Josh will be the first to do that. I think the further action is going to be more threatening letters and more complaints, not any action.
All right. Well, thanks, Matt, for that explanation. Let's go on to the next question. Are the CCRs and amendments still the governing documents for the homestead maintenance area? David, do you want to tackle this one?
They are the governing documents for the homestead maintenance area, also known as the common open space. By the way, just to toss something back to Matt for briefly as a clarification, while this lawsuit is pending, the defendants bringing any kind of action against any of the class members leaves it open to us to defend against that action, especially if they bring it against many of them. So I think we have, I think what Matt is describing is something that, a scenario that would be if we weren't in a litigation environment right now.
Thank you, David. That's a really good point. And so, I would add what the court says, and that is that this lawsuit is pending. If MJ so the first point is that in order to do anything with a lien, MJ Management has to file a lawsuit. If MJ Management filed that lawsuit, we would have it consolidated into this lawsuit and become part of this lawsuit. And that would have two consequences. The first consequence is that nothing would happen in that lawsuit until this lawsuit was decided. And the second is that if you're the one that they file a lien against and sue, you would find yourself with a lawyer for free. So it's not going to cost you anything to defend it because it would be part of this lawsuit. But so David's right. The fact that this lawsuit is pending makes it doubly difficult for them to do anything to you, because anything they try to do is going to be wrapped up into this lawsuit and all decided at once. Thank you.
Great.
Good, we got you. So the CCNR's amendments, they are still the governing documents for the homestead maintenance area. And I won't give any advanced billing to any further questions, but we don't call it the homestead maintenance area. We call it the common open space. It's defined in the master declaration at least 40 some odd times. And it's a very important definition, as you'll learn as we go through this evening.
Sounds good. Thanks, David and Matt.
Right.
Okay, next question. Are the amendments valid?
Easy question. I'll start. No. We have at least 4, if not 5 or 6 grounds for them not being valid. Number one reason that they're not valid is they don't comply with the Common Open Interest Act, the Washington State Act that was enacted in 2018. They're not in compliance with those. They're not in compliance with the original PRD agreement that was signed 30 years ago. They're not in compliance with the Lynden ordinances, which require, among other things, the sign off of the city of Lynden before any changes are made to the CCNRs. They're not in compliance with the CCNRs themselves. They're conflicting. They say one thing and they don't allow another. And last but not least, they're not reasonable. They're not in. Well, I'm going to punt this last one to Matt because it's his favorite. Go ahead, Chihuahua me.
Well, no, I will. And so, and what I was first saying is that everything David just said is accurate, true. But
Hey, Matt, can I interrupt one second before we go forward?
you may.
When we use acronyms, let's spell them out. PRD, for instance. What is a PRD?
A PRD is a planned residential development, which is an idea that has taken hold across the state and the country. And what it is when you have a larger area than just a plat. A plat is like 10 acres or something like that. A planned residential development is when you've got a whole big area you want to develop as a cohesive neighborhood. In this case, it was 250 acres, including the golf course. And the idea is that you have a plan for the whole neighborhood. Usually there's commercial and things like that. And in this case, there wasn't, but that's fine. So a PRD is just a development plan for an area that is undeveloped. At the time that the Homestead PRD was enacted, for example, it wasn't zoned for residential use. That had to change. So it was this plan that we want to create a new neighborhood here in this great big area. That's what a PRD is.
Great explanation, Matt. Okay, go ahead and continue with the amendment.
What David was saying, and the last part is that amendments to restrictive covenants are sort of a difficult issue because courts have recognized that people have valid expectations based upon their restrictive covenants. You move into a neighborhood that restrictive covenants, you assume they're going to stay. And so if someone wants to change those without the unanimous consent, the changes have to be consistent with the plan. Well, these aren't consistent with the plan at all because the plan is what the original Declaration of Covenants says, and the amendments are very, very inconsistent with those. So for that reason, among others, these amendments are invalid. And I would just really quickly point out that when MJ Management signed these amendments, they signed them saying that they were signing them as in for 18 Paradise, which 18 Paradise is unhappy about.
I got it.
And so
Please mute your audio.
there's a
Mute
whole
your
bunch
microphone.
of these issues out
Yeah.
there, but
I don't know what I did, but I
I
got
don't
it.
know. I think we finally got it, Larry.
okay, but the long and short of it is that for
What?
many reasons,
If it screws up,
these amendments
Did-
are
did-
invalid completely. And the last thing I would add to what David said is that they don't even say what Mick and
you know
Josh.
what it is here?
They don't say that they can assess, they can impose a special assessment for storm damage. They don't say they can impose special assessments for every year back to 1992. So, I mean, these guys are like the Keystone Cops. They can't even do their wrong thing right. But in response to the question, we believe the amendments are completely and utterly invalid for more reasons than we could list.
Great. Thank you, Matt.
I think Tom
Clarify,
wants to.
Steve?
Yes. Yes, Tom?
Yeah, I just wanted to add to that. There is 7 amendments to the declaration, but what Matt and David were referring to were the 6th and 7th. The first 5 amendments were basically to add property to the original PRD plat, and those were recorded in the first 3 years, so by 1995.
And we're done properly. And we're done in accordance with the requirements.
Okay. So when we talk about are the amendments valid, it's concerning the 6th and 7th amendment.
Yeah.
That takes us to our next question. I believe this is the 6th amendment. Was the $83 assessment for storm damage valid?
No, there's no provision in the master declaration for a special assessment to be charged under the CCMRs.
Okay. We already answered this question.
Hang on,
So
if I might add to what David just said really quickly,
sure.
and that is this: what the 6th Amendment says is that the declarant may impose on any and all parcel owners a special assessment for the purpose of funding improvements to the common space and or maintain a reserve fund. So what did they do? They turned around and imposed a special assessment for storm damage in 2017 and 18. That's not even on the list of things they can do it for. So it's invalid in addition to the reason David just said, because the 6th Amendment doesn't even allow a special assessment for storm damage. End of story. Thank you.
Okay. Thanks, Matt. Next question. Why a lawsuit? Why not negotiation? Tom, why don't you take this one?
Yeah, I'll start out on this one. I'm Tom Stair, by the way. I live at the Point condos just north of the timeshares. I've been here for over 10 years. I'm president of our Condominium Owners Association. And in early last year, I volunteered for the Homeowners Advisory Group, known as the HOAG. And in that group, we spent 2 or 3 months trying to negotiate with MJ Management. We're optimistic at first, but kept getting strung along. And then they finally pulled out of negotiations. So we had no choice but to go to litigation.
Great.
Can I
Thanks,
add something really quickly? And that is this: when this lawsuit, before this lawsuit was a lawsuit, when we first became involved, I did my research into Phil Burai, who is the attorney for MJ Management. And my research suggested he's a reasonable guy. I mean, lots of things that I read about him suggest he was somebody who was about making sense. And I sent him a lengthy letter and I said, listen, can we please just do the right thing here? And he sent me back an email in which he said, it makes sense to transfer the common areas to the association. But what happened next is it got to 18 Paradise, Mr. Chin's company, and he immediately killed it. And the problem here is we cannot negotiate with MJ Management because they have no power. The only person who can do this is 18 Paradise, and 18 Paradise just sees money. And they see this money coming in, and as soon as it hit 18 Paradise is when it all stopped. And that's the reason that this is a lawsuit and not a negotiation, because 18 Paradise wants the money and won't negotiate. If this were just MJ Management and Phil Bureau, we would have this solved, but he can't solve it. Thank you.
Thanks a lot. So MJ Management is the leasee of the golf course. They do not have any ownership at all. Nick and Josh do not have any ownership in Homestead Golf Course or the common open space at all.
None.
Okay, next question. Can I opt out of the PRD?
Go ahead, Matt.
What?
Can I opt out of the PRD?
Take it, David, take it away.
Well, these are easy questions. The answer is no. But the reason that the answer is no is that the PRD is a master declaration that binds all of the property. So you can't opt out of it, which is why we have to undertake this lawsuit, so that you can at least gain control of it, at least control of it that affects the place where you live.
Hey, David, can we say that in layman's terms that when people purchase property at Homestead, they essentially sign a contract with the developer who is now the declarant?
Yes, that's exactly right.
Because it's recorded. Because it's recorded. And because it's recorded, when you buy property in Homestead, you buy subject to. And what you buy subject to is the restrictive covenants, which is what sets all this out. You're right, Tom.
Great. All right, next question. Who owns the golf course?
18 Paradise, which is owned by Morris Chen, who lives in Richmond, British Columbia.
So Morris Chen is not, he does not even live in the United States?
No, he does not.
He's Chinese and lives in Vancouver, as far as we know.
Okay.
Actually, he lives in Vancouver. You're right.
Okay, so the owner of the golf course has a lease for somebody to manage the golf course. It's just like renting a house, basically. MJ Management is the leasee of the golf course. They have no ownership rights at all. And they pay a fee to Morris Chen, or AKA 18 Paradise, for the privilege to lease that golf course.
Correct.
Okay.
It's more complicated than that. And the reason it's more complicated than that is this. Normally, when a real estate investor buys property, they hire a management company, which is essentially what MJ Management is. And that management company manages it and gets a percentage of the rents. That's what they get paid. In this case, what he says is, you're going to pay me X dollars per year and you guys can keep all the profits. And the result of that is that from MJ Management's perspective, every dollar they pay in maintenance is out of their own pocket. Every dollar they spend for repairs is out of their own pocket. So they don't want to. So it's important to understand that this weird agreement that Chen has with them is, you're going to pay me X dollars per year. You keep all the profits. And I'm out of here. And what that means is he's disconnected from the maintenance. He is.
He's guaranteed 10 grand a month, no matter what happens.
10 grand a month, no matter what, and that's all he cares about. He doesn't care what they do, and because they have to pay $10,000 a month, if they cannot do the maintenance and save money, they will.
Okay. It sounds like it's in MJ Management's best interest then to make as much money as they can, because anything above and beyond $10,000 a month, was that the amount that you mentioned was the rent?
Right, basically, more or less, yeah. And from
Anything
MJ
above and beyond
Management's
that
perspective,
amount
every
is
dollar
money in
spent
their
on
pocket.
maintenance is out of their pocket.
Right.
So then,
Okay.
They don't want to spend
Hey,
money.
we have a question from the group chat I'd like to throw in here. And it's related to this topic. The question is, how do we get road repairs, cracks, walkways, etc., repaired, as well as bridges?
That's different for each of those issues. So let me just grab this if I might. So on road repairs, cracks, and so forth, there are a number of private streets within the Homestead PRD. Without exception, where there are private streets, the plat says that the owners of property adjacent to those streets will pay the cost of maintaining them. So that is, on its face, not an MJ Management issue. It's a homeowner issue. With respect to the walkways and bridges, the city took over the path through the Fish Trap Creek area in 2014, and they're responsible for that. So this is kind of a complicated question with many parts, but there's not much here that really genuinely affects common areas for the benefit of everyone.
So am I hearing that correctly? What was once common area, the pathway through Fish Trap Creek, is now taken over by the city?
The pathway through Fish Trap Creek and the bridges over it were taken over by the city in a 2014 agreement. Those are now, the city now maintains the path, provides the garbage cans, maintains the bridges. And if MJ Management says they want money for it, they're not exactly telling the truth.
Okay, well, thanks, Matt.
Thank you.
On to the next question.
that
Why does MJ Management want to keep the maintenance fee?
was already
I think that's pretty self-explanatory. Anything above and beyond the rent that's due to 18 Paradise is money in their pocket. So
Exactly.
if they can raise the maintenance fee on the homeowners, it's extra money for them.
Exactly.
And by the way, the increase from 36 to 93 increased the annual maintenance fee from 260,000 to 685,000. That's a lot of money to maintain 9 acres of property.
So currently, with the number of homes in Homestead and paying $93 a month, how much did you say was the total yearly collected?
The total amount of the fees that they are demanding is $685,000 per year.
To maintain how many acres?
Less than 9, 8.77.
Great. Okay. Thanks. Let's move on.
Not bad work if you can get it.
Who raised our rates? The managers of the golf course or the owner? David, why don't you take this one?
I'll start because I know Matt will finish.
Okay.
They both did. It's only the declarant can file the amendments which enable them to go out and, under any color of law, demand more money from the homeowners. But according to the documentation that we've seen and the theories of the case, the owner has delegated. The authority to the managers to do those things on its behalf. So they both did it. We're, Mick and Josh and MJ Management are what we would call in the law men of straw. They're of no substance. Getting a judgment against them or having them in the lawsuit is not useful, not very useful. So the owner is the declarant, and he obtained that right when he purchased the golf course, and ultimately, it's Mr. Chen who has to okay or not okay the amendment. Matt, anything to add?
Well, I would say, David, that your answer is almost perfect. And that is that in terms of who raised our rates, the managers or the golf course or the owner, the answer to that question is the only person who can increase the rates is the declarant. The declarant, by succession under recorded document, right now is 18 Paradise. 18 and the argument that MJ Management has made is that our lease agreement conferred on us the right to increase, to amend the restrictive covenants. And MJ Management and 18 Paradise has been very, very dicey about this because it wants the benefit of that argument, but it doesn't want the pain of that argument. So it's trying to sort of have it both ways, if you will. So the answer is the only person who could increase the rates is the declarant. The declarant is currently 18 Paradise. MJ Management claimed to increase the rates as 18 Paradise. So that's the short answer, is that they claimed that they were 18 Paradise when they increased the management fee, the maintenance fee, and that's the sort of the end of that.
Great. Okay, thanks, Matt. All right, next question. Can they charge me interest and penalties on my unpaid balance?
I'll start. Anybody can charge anybody anything. The question is, are the charges legitimate? And that's what we're fighting in court. And I would say, and we strongly believe that we have an excellent case. Will they try? They may very well try. Given this latest letter that they sent out, trying to threaten the class members, I wouldn't be surprised if they did something like that. If the charge is not legitimate, you do not need to pay it, and there will be no interest upon it. Matt?
Well, what I would say in response to that is that there is a statute, and for those keeping score at home, it's RCW 19.52.010, which states that if you owe someone money and there's no stated interest rate, then the interest rate is either some calculation or 12%, whichever is higher. And 12% has been higher for ages. So it's 12%. So if you owe someone money and don't pay them, it accrues interest by law at 12%. If they prove in the end that you owed a maintenance fee and did not pay it, you would owe 12% interest on that, which sounds really scary until you realize that 12% interest on $93 is 3 cents a month.
Great. Okay.
And not exactly something to change your life plans about. So, and now the next question was penalties. No. They cannot change penalties. They can charge 12% interest and nothing else.
Okay.
End of story.
All right. Thanks, Matt. Okay. Next question. Do we have a homeowners association? Tom, do you want to go ahead and take that one?
Oh, yeah.
I'll start.
Okay.
The simple answer is no. The declaration says that we have a homeowners association, but have no power. We have no authority to make changes. We can give them advice, but you don't need a homeowner association to give them advice. Anybody can give them advice. MJ is forming, so they say, or they have formed an advisory board that's going to give them more advice. But no, we don't have a functioning homeowners association.
Okay. Anything
Bob,
to add?
I would
David and
add to
Matt?
what you just said, if you don't mind,
Not at all.
that paragraph 4.1 of the Declaration of Restricted Covenants says there is hereby formed a homeowners association called the Homestead Owners Association. I think it's paragraph 4.2 that says, yeah, but as long as they own the common areas, you can't do anything. And so this is a difficult question to answer because on one level, yes, a homeowners association was formed by the restricted covenants. On the other hand, the restricted covenants also said it can't do anything. And what I would rely on here are the words of the guy who created the Homestead PRD, James Winstrop, because we took his deposition under oath, under penalty of perjury, you know, the whole thing. And I asked him, okay, so you made a decision not to allow the homeowners to have a real homeowners association with homeowner association rights. Is that true? And he answered, that would be true.
Okay.
So you have a homeowners association in theory, but you don't have a homeowners association at all. That's the answer. Thank you.
Okay, we're going to go ahead and take a question from the group chat. What can we do if the owner wants to close the golf course and build homes?
First of all, you can't build homes on that golf course. The city of Lynden will not allow it, so that will never happen. Second of all, we already know that there's parties interested in buying the golf course, just a question of price. That golf course will be bought by somebody. There's already action behind the scenes, we know that. So I don't think you have to worry about that happening. Might the upkeep of the golf course deteriorate? That's possible. That happened if you've lived on the property long enough and you remember when Weinstra had his problems and had to wind up Homestead Northwest, there was a period of months between the transfer between Homestead Northwest and Raspberry Ridge where the property went into some decline. Some of you will remember that. That's a possibility, but the new owners will bring it back up to speed. And you know, the pandemic comes over, Canadian golfers come back. This is a great golf course. It's well designed. It'll have demand and it's marketable. So.
Great. Thanks,
Further to
David.
what David said really quickly is this. A PRD results in a contract between the developer and the city. And in that, the whole PRD process gives the developer benefits for the rest of the property because of what they give up for the golf course. No one could ever turn the golf course into residential properties because there's an existing contract that says they'll never do that. No one could ever turn the golf course into residential lots because they are forbidden from doing so by an existing contract and by the PRD itself. It is not possible that the golf course could become houses. There also is a requirement for a golf course management plan, which means the golf course always must be a golf course. There is a 0% chance that the golf course could ever become anything other than a golf course. Please relax.
Okay. All right. Thanks, Matt. Hey, while we're on this slide that's shown on the screen, do we have an HOA? I want to just mention that there's other HOAs in the city of Lynden. There's other PRDs in the city of Lynden. And each and every time that PRD, the declarant of that PRD has turned over the maintenance of the common areas to a homeowners association. And so the residents of the PRD govern their own common open space. So I just wanted to mention that there's several PRDs in the city of Lynden, and each of them have been turned over to their own respective homeowners association.
There are many, many PRDs within Lynden, many PRDs within Whatcom County, many PRDs within Washington State, and many PRDs with the United States. And uniformly in them, there's a homeowners association of the owners that manages their own property. Yeah, that's true.
Thanks, Matt. Actually, the answer to that question is, do we have a homeowners association? Some places like Tom's place actually have two. I mean, they've got their own, the Point, and then they have the Homestead. All right, let's move on.
Okay.
Moderator,
The next question, what are common areas?
why don't you start with Matt, Tom on that, sorry.
Tom?
Yeah, I'll start with that. So the declaration says that common areas are intended for the common use of all property owners in Homestead. So it's supposed to be common areas that are owned commonly, which currently they're not, they're owned privately. The declaration also says that there will be about 8 acres of common open space, which is pretty close, because there's close to 9, and there's 1 acre that's questionable in my mind.
Yeah.
The majority of the common areas, the Homestead Park by Fish Trap Creek, that's over 70% of all the common areas. It's about 6.5 acres. The other common areas are in Mayberry neighborhood and on Sunrise Drive.
Okay.
All privately owned by Chen. Not,
That's a
and,
beautiful.
and again, it's not the physical space. These areas are being used as a revenue source.
That's a beautiful map
Attorneys,
you have behind your head there, Tom. And I think we have a copy of that map on the website, don't we, moderator?
that's right. There's a copy of the map on the website. If you're interested, take a look.
Mm-hmm. And with the maintenance fees at $93 a month and over 640 homes paying that, that's a lot of money to collect. So I'm sure we got swimming pools and clubhouses and everything else in the common areas. Is that right?
No,
No,
We
no,
have grass.
no,
Okay.
no, no.
All right. Thank
We
you.
got grass
That's what
and
I thought.
trees. We obtained bids from outside companies to maintain the common areas to the highest possible standard. And it was about $50,000 a year. Not $685,000, $50,000.
Okay, thank you. Whoops. My slides are going on me. Okay, the next question, what is Homestead responsible for and what does it cost?
Tom?
is this, what is,
As far as taking care of the common open space.
Okay.
Tom, do you want
okay,
to talk about the quotes?
yeah, in addition to the common areas, the declaration says it also include maintenance of entry signs and landscape. So there's 3 or 4 signs around Homestead Boulevard, and I guess I question even that because 3 of the 4 are signs for the golf course, not for Homestead. It also includes mailbox surrounds. Not sure what that means. Streetlight electrical power bills, and maintenance of lights not maintained by the city of Lynden. So again, what Matt said, we got bids from 2 or 3 different maintenance contractors for the common open space, and all 3 of them came in at about 65,000 a year. The electrical power bills, we believe they're around 35,000 a year, so that's 100,000. So the rest of it, MJ Management is collecting, what'd you say, Matt? 685,000 a year?
685,000 a year.
So we're 500,000 or 600,000. I don't know where that money goes.
All right, thank you, Tom. Why can't we just give the city the common areas for a park?
We did offer that to the city. We've entered into a discussion with them. They are currently not interested. That may change. It's adjacent to Fish Trap Creek. Most of the property is, and it would be suitable. But in their ordinance, it says that they are not inclined to take common open space from PRDs and make them into parks. So that's their policy. So they would have to reverse their current policy.
Well, they don't like taking control of property because then they're responsible for it. But they've already taken a lot of responsibility for the trail through the biggest part of our common areas. It wouldn't be a big step for them to take the next step to say, okay, we'll take the rest of it. And we're working on that. And that's something that should happen, because for those of you who are familiar with the trail through that area, everybody in the city uses it. It's a common amenity. It should be a park. So we are working on that, but we got work in progress to make. Okay. But it should be, but the answer is the city just says no. The city says no.
Okay, thank you, Matt. What are the maintenance fees for? I think we covered this one already. The maintenance fee is spelled out in the declaration that they are for the maintenance of the common open space, a little over 8 acres. Okay, if each parcel owner pays the $93 a month maintenance fee and it adds up to almost 700,000 per year, I think it's a little bit more than that, 800. Has MJ Management shown any accounting to justify or explain why they need so much money to maintain the common open space? David, do you want to take a stab at this one?
Yes, so we've received accounting from MJ Management. There's several times. If you read our complaint, it's fairly well detailed. So MJ Management has initially tried back in 2019 when they did their amendments to justify the reasons why they need it. They sent us some accounts that turned out not to be based in reality. So those were not good accounts. During the course of the litigation, they have produced a couple more versions of their books. Those accounts, according to the testimony of MJ Management, are hopelessly commingled, and they really are not in a position to explain how the money is being used. The money goes into basically a slush fund, and they use it as they wish. We also have obtained evidence that at least $200,000 of that money in the year 2019 was expended on a different golf course called Sea Links over in Birch Bay. So we don't have any accountability from MJ Management is the bottom line here. That's one of the remedies that we're seeking in the lawsuit.
Great.
Hey, Steve,
Yes.
just as a suggestion, in the last letter, MJ Management, I guess this letter's written by their lead accountant. It's not signed, but maybe he knows the answer.
We don't know, and they don't know. And that's the answer. No, they haven't provided any accounting to show where the money goes. I haven't shown any accounting to show why the money's needed. As David said, we just don't know because they can't know because everything's all mixed up on their part.
So we've asked MJ Management to tell us exactly how much they spend on maintaining the 8+ acres of common open space. And they can't do it because their books are commingled with the maintenance required to maintain the golf course. They say they're operating the common open space at a deficit, and that was the reason why they had to increase the maintenance fees so great. But they cannot show in accounting how much each year they pay to maintain the common open space. So with that, let's go ahead and, okay, next question. Does 18 Paradise have a legal contract with the city of Lynden to meet certain ordinance requirements?
As a declarant under the CCNRs or the Master Declaration, 18 Paradise became the successor to the prior contracts that were negotiated and signed by Homestead Northwest and then passed on to Raspberry Ridge and now on to 18 Paradise. The answer to that question is yes. And even if they didn't have a contract to meet the City of Lynden ordinances, they're located in the City of Lynden, and every piece of property in the City of Lynden is subject to City of Lynden ordinances. They are not in compliance, and we are complaining with the City of Lynden, which is why they've been added as a defendant to get them to do something about enforcing their own ordinances, which they have not done.
Okay, that's great. We have a question from the group chat that is for this subject. So is the common open or the City of Lynden paying heed to our case? Are both attorneys talking to the city?
Yeah, Matt has done far more talking with Lisa Keeler, the city's representative in this matter, than I have, but we've both talked to her. We will be in court with her again next Friday. The City of Lynden has been cooperative in providing information, general information, to Tom, Matt, and myself. About documents that have been filed. We have not yet taken their deposition to get down into the details and to get evidence on the record. That is next on our schedule.
I would add a couple of things to that. First, I would say that the city's approach to this whole problem has been to try to cast itself as a sort of a neutral observer. They take no responsibility for the fact they completely messed up the approval of the original PRD. They don't want to talk about that. They don't want to take responsibility for it. They don't want to do anything with it. And so the city just wants this to go away. That's all they want. They don't seem to care that 5% of the city's population is a class member. They don't seem to care that this drastically affects the lives of many people. They just want out. And that's the message that I've been given and in repeated contacts with the attorney for the city. I can only contact the attorney for the city. I can't contact the city itself, so I don't know what they're thinking. But
as attorneys, we're not allowed to contact the other party. That's why Matt says he can't contact us.
That it would be helpful if someone, I would love to show up at every city council meeting from now until eternity to say, what are you doing about this? Why are you not paying attention? Because this is a subject the city of Lynden should care about. They should care about because it affects more than 5% of its population. They should care about because it affects you guys very, very drastically. They should care about me doing something about it other than trying to get out of this lawsuit.
Okay, so what I'm hearing is the City of Lynden actually has the power to make Homestead, the declarant, meet the requirements of the PRD ordinance and turn over the common open space to an approved homeowners association. Is that correct?
Can I grab that one real quick because it's something that I have particular knowledge about, okay? And that is this. If you build a house without a permit, the city's going to come to you with called a notice of violation because they have the right to say, listen, you violate, we require a permit to build a house and you built one without one. The city could come do that. There's no limit on how long after it's done that the city can do that. The city of Lynden could at any time come in and tell 18 Paradise, you are in violation of the requirements for a PRD. You don't have a homeowners association and you privately own the common areas. The city could come in and tell them, listen, you guys need to fix this right now or we're going to start levying fines. And the city could make them comply, but they won't. I don't know why, but they won't. The city could fix all of this overnight.
Thanks, Matt. What is the procedure for Homestead to place the lien?
I think we discussed this one already, Steve.
Yeah, we'll go ahead and skip this one. Why is it taking so long to get a judgment? David, will you please take this one?
Sure. So litigation takes time and it can take longer depending on the resistance of the defendants and their willingness to cooperate. We've had significant resistance. They've made several procedural moves just to drag this out. They took the case from Whatcom Superior Court and they took it up to federal court. And then they made some motions up in federal court, and then we moved it back to Whatcom Superior. Anyway, these are details that are just part of the litigation history. Typically, it takes at least a year or two. A year would be lightning speed to get a trial. Our next thing that we're going to do after our motion to amend the complaint is approved next week, is to set the trial date. We're targeting the end of this year for the trial date. That gives us plenty of time to finish doing the depositions that we need. That's taking statements from the opposite parties and witnesses. We've already taken care of Mr. Weinstrom, so we've got to take care of the city of Lynden. We've got to depose Maurice Chen and 18 Paradise, and then of course Mick and Josh. Deposing Mr. Chen may require me to go to Canada. I'm also a Canadian lawyer. We have facilities up in Canada. I may have to do it up there. But in any event, so yeah, these things are time consuming, and that's sort of where we are in the litigation process.
Great, thanks, David. We have a question coming in from the group chat. The question is, I'd like to know why the interim decisions made by the judge so far seems to be not in our favor. Is that likely to change in the future?
This judge is a cautious judge. And so of the motions that we've had before him, Dave, we had a motion to classify the action as a class action. As far as we know, that's the first type of class action motion that the judge has seen, as it was a novel action for him. He was cautious. We had to go back on reconsideration to bring some more information to his attention, and the matter was the case was certified as a class action. In terms of the summary judgment applications that we've brought, once again, a judge does not deny summary judgment applications. A judge can simply find that there may be some other facts that the court should consider before a decision is made on it. That is what the judge has said. In response to that, we deposed Mr. Weinstrom because the judge was asking for information about, what the person who drafted the declaration intended when he initially drafted it. So we have Mr. Weinstra's testimony on that. We'll be going back into court very soon with further motions for summary judgment and preliminary injunctive relief requests to move the litigation forward. Those will happen most likely after we get a trial date set.
Further to what David just said, I would like to say the following things. First, I have complete confidence in the judge that we have. The judge that we have is a competent, thoughtful, careful judge who is doing his best to do the right thing. And I think that we forget that at our peril. He is a very cautious person, and he's more cautious now because his decision directly affects 850 people, not 3, like a normal case. It's taking so long because our judge wants to be sure in his own mind that his decision is right. And David said something that's critical here, and that is this. This judge has not once ruled against us on any question. He has said, I want more evidence. He's never said you're wrong. He's not given any indication that he might rule against us.
Okay.
So I
Thanks,
think
Matt. Let's go ahead and move on. We have less than 5 minutes left in the meeting, and we have some more slides to take care of. Okay. The next question is, Homestead's infrastructure, including streetlights, sidewalks, and storm drain systems, seems badly neglected. And by the way, you can see some photos of this on the homesteadhoa.org website. Who is responsible for the upkeep?
That's an easy one. The declarant is responsible for the upkeep of all common open space. That's a defined term, and the items for maintenance are also a defined term that we've reported back to you today. So those broken streetlights, that's the declarant's responsibility to fix.
Okay. There's been some question about what exactly the storm drain system is. Can you talk about if it includes the ponds located on the golf course?
Over to Tom on this one, maybe.
Yeah, I can help. We've done a bunch of research on this, but one of the requirements from the city of Lynden for the developer was to provide a storm drain system for this area, because previously there was flooding and lawsuits, and there was a lot of problems. So that they did that, and so now there's the storm drain system includes several ponds. The ponds also double their water features in the golf course as very also for irrigation holding ponds. In addition to that, there's, I think, six other neighborhoods that drain into the storm drain system, in addition to Homestead, as well as over 3 miles of public roadway. So I think as far as who's responsible for the upkeep, that question may be posed to the city of Lynden as well.
well, so when Lynden adopted a PRD ordinance, when they first allowed planned residential developments, a big part of their just motivation was storm drainage, because they have a huge storm drainage problem. And this was perceived to be a solution to that. And Homestead was supposed to be a solution, not just to the area, the Homestead residential area, but a bigger area, because their ponds were detention ponds for the entire storm system. So the ponds in the golf course are part of the storm drainage system, not just for Homestead, but a much bigger area, as Tom said. And so the responsibility for that is mixed as between Homestead golf course in the city, but is not of the homeowners, you don't have to provide storm systems for your neighbors. No, you don't. Okay. And so the answer to that is that it's a complicated question. It really is. But the answer is that it's as between the developer, because they took a lot of responsibilities on, in the city.
Okay, next question. It's been rumored that MJ Management has handpicked an advisory board. Do they have any authority?
They do not have any authority, only the declarant has authority. So it mentions an advisory board in the CCNRs. Frankly, after we brought to the attention of the court that the declarant is not in compliance with the Washington State Common Ownership Interest Act, they moved to try to set up what they will try to pass off as a homeowners association, being the advisory board, to try to bring themselves into compliance. They said that in their court documents. So, but no, they do not have any authority. The only authority is with the declarant, or if the declarant transfers the common open space to the Homestead Owners Association, then we will have authority. Those are the only two parties that have authority.
Perfect, Matt. Or I mean, David, thanks.
You're welcome, Steve.
Next question, should it be put in force? What exactly does an injunction do for us?
Well, the question is a little vague because should what be put in force, but what does an injunction do for us? Injunctive relief is difficult to obtain. However, if we're able to demonstrate that we are likely to prevail in the cause ultimately, and that there's irreparable harm that can be done to the class members by the defendants continuing to take money, then it is possible for us to get injunctive relief. Our strategy to do that would be to ask the court to set the fees back to what they were before the 6th and 7th Amendments. We can litigate whether the 6th and everything from 2018 through the 2019, whether that's valid or not. But so injunctive relief and or further summary judgment rulings are something that is high on our radar, and it's essentially what we're going to be doing next.
Okay.
Together with depositions.
I would add to that briefly.
Thanks, David. Hey, Matt, just one second. On that same topic, David, you set up an HOA in our name and you filed it. Can you talk a little bit about the HOA that has been set up and is ready to accept the common areas?
The Washington State Common Ownership Interest Act provides that homeowners associations cannot be unincorporated. They have a provision so under that it can be incorporated. So back in January, in wild optimism that there would be some negotiated result through the Hogue, I, in consultation with several of the plaintiffs now, decided to take the initiative to incorporate the name Homestead Owners Association. It's a nonprofit corporation, and it's essentially a placeholder until this litigation is complete. It doesn't and cannot do anything because the declarant rights have to be transferred to the Homeowners Association. So when that happens, then it will operate as the corporate entity for the Homeowners Association.
Great. So it sounds like we have everything set up to accept the common areas over to homeowners.
Catcher's mitts on, just throw the ball. We're ready.
Okay, on to the next question. Oh, we're almost done. They skipped the last slide. What are the next steps in the litigation?
So I know Matt wants to weigh in here a little bit, but we're negotiating on a trial date, and that will happen after our second amended complaint, which we will post on the website, by the way, after the second amendment complaint, which brings more of the city of Lynden's culpability, and it just focuses the responsibility of the defendants more clearly. So once that's been